Students are joining. We will start in a minute. Ashish, I can see your comment. Hello, good morning, and welcome to Baiju's Exam Prep. Yesterday, we initiated a discussion on fundamental rights, part 3 of the Constitution. What did we discuss? Part 3, part 4, capital A. Fundamental rights, directive principles of state policy, fundamental duties. Although these are three separate units, distinct parts of the Constitution, yet when we look at them together, they concretize, they give shape to the lofty goals that are mentioned in the preamble. The goals of justice, liberty, equality, fraternity, dignity of an individual. In political theory, we say fundamental rights are negative obligations, basically restrictions, limitations on the powers of the state. The state is told, don't interfere with the life and liberty of individuals. And the idea of fundamental rights is to promote political democracy. When it comes to directive principles of state policy, we say these are positive obligations. Here we are asking the state, please interfere so that in social sphere and in economic sphere, there can be development of the people. And the objective of fundamental duties is to make citizens responsible and at the same time ensure that there is one objective of the Constitution mentioned in the preamble, that is of fraternity, a sense of common brotherhood, that is achieved through fundamental duties. But when we look at these fundamental rights, we then discussed what is the position of fundamental rights when it comes to England, when it comes to United States. And we discussed that in England, there is no such thing as fundamental right. Individuals are allowed to do whatever they want to do, except those things which are prohibited by the legislature of England. There is no such thing as fundamental rights. And there is no distinction between a legal right and a constitutional right or a fundamental right. Anything can be said to be the right of the citizens unless and until you do something which is expressly prohibited by the legislature in England. And the courts in England will protect you against the arbitrary actions of the executive, not the arbitrary actions of the legislature. But when it comes to United States, the framers of the US Constitution thought that we should protect our citizens not only from the arbitrary actions of the executive, but as well as the arbitrary actions of the legislature. And there we see a concept known as judicial supremacy, which means if at all restrictions are to be imposed on fundamental rights, those can be evolved through the decisions of the judiciary. And in India, we follow a concept where there is a set of fundamental rights provided to the citizens, but if at all any restriction is to be imposed on these fundamental rights, Constitution itself gives power to the parliament that you can impose restrictions, but those restrictions have to be reasonable. And the job of the judiciary is judicial review, to review this law, to see, to test whether these restrictions imposed by the parliament are reasonable or unreasonable. Then we jump to Article 12, where I told you that throughout this chapter of fundamental rights, we come across a term known as the state. The state cannot do this, the state cannot do that. Against this entity state, your fundamental rights are enforced. which means if at all you claim tomorrow that my fundamental rights have been violated, the courts will have to then look at who is the violator. If the violator is the state, the court will extend your protection. But if the violator is a non-state entity, the courts cannot protect you on the grounds of violation of fundamental rights, because fundamental rights are enforceable against the state. And that definition is provided under Article 12. Then Article 13 basically talks about all the laws which are in force in this country prior to the commencement of the Constitution. Can these laws continue after 1950 as well? Yes, provided these laws are in conformity, are in agreement with fundamental rights. The moment they violate fundamental rights, and that is for the judiciary to decide, this is how we see that there is a concept called judicial review. Judiciary will review these laws to see, to test them on the ground of fundamental rights. If they violate fundamental rights, those laws will not continue. If only few clauses of that law violate fundamental rights, only those clauses would be set aside, would be declared void, unconstitutional. The rest of the law continues. That's what we discussed yesterday, doctrine of severability. Then the state cannot make any law to delete, to modify, to abridge a fundamental right. But this law means an ordinary law. That means through an ordinary law, through ordinance, through rules, through regulations, through notifications, through customs, through usages, fundamental rights cannot be violated, cannot be deleted, cannot be modified. But fundamental rights can be deleted, can be modified only through a constitutional amendment act passed by the parliament under Article 368, subject to basic structure. No fundamental right which is part of the basic structure, which we will discuss, can be amended, modified, deleted by the parliament, even by using Article 368. Clear? Yes, no, maybe? Okay. Now let's explain all these fundamental rights one by one. The first category we have to discuss is right to equality. There we will discuss Articles 14 to 18. You don't need to remember all these article numbers, but do remember Article 14. Why? Because you may have to quote it multiple times in your answers, be it essay, be it your optional subject if you have, be it the GS. Article 14 talks about two things. The state shall not. And what is the state? We know that under Article 12. The state shall not, what is it? Negative obligation, restriction, limitation on the state. That what the state cannot do, it cannot deny to any person. Which means this fundamental right is not available only to the citizens. Otherwise, it would have mentioned any citizen. This fundamental right is available to any person, which means citizens as well as aliens. The state shall not deny to any person what? Equality before the law or the equal protection of the laws within the territory of India. Two things the state cannot deny to any person within the territory of India. What are these two things? Equality before law and equal protection of the laws. These two concepts, equality before law and equal protection of the laws, may appear similar, but there is a distinction, there is a difference. And what is that difference? Let's look at the difference. Equality before law or equal protection of the laws does not mean the same treatment to everyone. If I treat everybody equally, it won't be equality. Why? I will explain. No two human beings are equal in all respects. The same treatment to them in every aspect would result in an unequal treatment. I have a class of 100 students. there are 5 to 10 students who are very poor. Poor not in terms of material conduct, not in terms of money, but poor in terms of their grasping power of understanding things. You might have witnessed this in your school. There's a teacher teaching 40 students, for example. Once the teacher has explained the concept, the teacher goes back and focuses, pays more attention to 3, 4 students. What have you written? No, 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 this is not like that. No, I'll show you how it is done. That means the teacher is giving special treatment to some students, not because they are special, but they require more attention because they are weaker than other students. If the teacher would treat every student equally, then it would not result in equality. It would result in an unequal treatment because no two human beings are equal. To understand that fully, we say equality before law is a negative concept. Negative concept in the sense it imposes negative obligations on the powers of the state. And we have borrowed this from England. And we say this equality before law is the corollary of A.V. Dicey's rule of law. A.V. Dicey was a British constitutional expert. What is corollary? For example, if you have studied mathematics in school, which I'm sure you would have, if there is a statement given, what is the next inference that you can draw from the statement? What is the next result that you can draw from the statement? That is what we call corollary. We say equality before law is the corollary of A.V. Dicey's concept of rule of law. And what is rule of law? Number 1, no person shall be made to suffer in body or goods except for a breach of law. What does that mean? I'm teaching you right now, teaching you with all my honesty. Suddenly there is a knock at my door. The police comes and arrests me. Why? I have not violated any law. Have I committed any crime? Have I killed somebody? Am I an international? Am I a terrorist? Am I a thief? Am I a Vijay Mallya? I have not committed any crime. So why should I suffer in body? In body in the sense, why should I be arrested and detained in the police lockup, detained in the jail so that my liberty is snatched? Or why should my property be snatched? You might have read in the newspaper something known as bulldozer justice these days, something which was started by Mr. Yogi Adityanath in UP. Now there is a bulldozer Baba in UP, there is a bulldozer Mama in Madhya Pradesh. Chief Minister Shivraj Singh Chauhan. What is that bulldozer justice? Somebody protesting, whether violent protest or peaceful protest, and then the police looks at who are these protesters because CCTV camera and footage is everywhere. Now what the police does later on, they claim that this individual who was participating in the protest, whether violent or peaceful, his property is on the encroached state land. And then they call bulldozers and they destroy the property. And that is why you would read in newspapers, there is no rule of law in UP, there is no rule of law in Madhya Pradesh. What is that rule of law? If you have not violated any law, you should not be worried about getting arrested. If you have not violated any law, you should not be worried about your property being destroyed. Rule of law means no person shall be made to suffer in body or goods except for a breach of law. And when there was the practice of slavery in Europe and in other countries, for blacks, their property was confiscated by the state or by the whites. Their dignity was snatched. They were made slaves. Their lives were in danger. Their property was snatched, even if they violated no law. But since rule of law came into the picture, A.V. Dicey says rule of law's concept number 1, no person shall be made to suffer in body or goods except for a breach of law. A person can sue or be sued. It's not that only Brahmins can file a case and other communities cannot. It's not that only against the Dalits cases can be filed and not against other communities. So anybody can sue, can file a case against anybody. This right to file a case is not restricted to only some individuals or some communities or some religions. This is available to everybody. That is what we call the rule of law. And A.V. Dicey said, Constitution is the result of the ordinary law of land. Parliament can change this constitution. But why Constitution is the ordinary law of land? But sir, in previous class, in the first class, you said Constitution is the supreme law of land. You need to understand that this concept comes from England. This concept comes from A.V. Dicey, where in England they have an unwritten constitution. And any country where the constitution is unwritten, it is not the constitution which is supreme. It's the parliament which is supreme. Parliament can do anything. There, they have a parliamentary sovereignty. Parliament is sovereign, not the constitution. So long story short, what is Article 14, Part 1? Because Article 14 says the state shall not deny to any person equality before law and equal protection of the laws. What is equality before law? Both these concepts, they primarily tell us that you can't be treating everybody equally. Because if you start treating everybody equally, since no two human beings are equal, if you start treating them equally, it will result in an unequal treatment. But then what is equality before law and how is it different from equal protection of the laws? Equality before law, we say, is the corollary of constitutional expert of Britain, A.V. Dicey's concept of rule of law, wherein he says rule of law means no person shall be made to suffer in body or goods except for a breach of law. Any person can sue or be sued. Before rule of law came into the picture, the concept was king is the law. Whatever king says, that is the law. That means kings can change their positions as well, arbitrarily, without any logic, based on their own whims and fancies. But after rule of law came into the picture, we say law is the king. Sir, what's the difference? Simple. If king as an individual is making laws, it may be arbitrary, it may be illogical, because one person is making this law and nobody is infallible. But when a collective body such as a parliament, when a group of 300, 400, 500 people are making a law, that is why we say that law will be fair, because it's based on the collective wisdom of the people, not the wisdom of only one individual. That is why even the courts in India, they say when you file a petition before the court and you claim that a particular entity has taken an arbitrary decision, illogical decision, we can test it against one individual. Against one individual in the sense, if you tell us that president has taken an arbitrary decision, we will listen to it. The prime minister has taken an arbitrary decision, we will listen to it. A particular minister has taken an arbitrary decision, we will listen to it. But when you say parliament has taken an arbitrary decision, you will have to convince us. Because we don't attribute arbitrariness to a collective body. How can you say all the members of the parliament, they have taken arbitrary decision? Because it's a large group of people. So before rule of law, we would say king is the law. After rule of law came into the picture, we say law is the king. But sir, this equality before law is still not clear. Let's put it simply. Equality before law basically means three things. Number one, absence of special privileges. No matter who you are, there are no special privileges for you. No special privileges for upper castes or so-called upper caste. No special privileges for particular religion. Everybody is treated equally. Second, equal subjection of all the persons to the ordinary law of land. Do you see in India that when it comes to murder laws or Indian Penal Code, Indian Penal Code is applicable only to Hindus and not to Muslims? We don't see that. Do you see that murder charges are separate for Dalits and Brahmins? No. The laws are equal for everybody, equal subjection of all the persons to the ordinary law of land. And the third, no person is above the law. Only this polity teacher at Byju's, he can commit murder, he can commit dacoity, and nothing will happen to him. No action will be taken against him because he is above the law. Law is for everyone else, law is not for him. That doesn't happen. This is equality before law. That means law will treat everybody equally. But then this fundamental right is not absolute. When we say this fundamental right is not absolute, that means there are exceptions. And what are these exceptions? Number one, president or the governor is not answerable to the court of law with regard to the discharge of their official functions. And this is basis what happens in England. President or the governor, when they are discharging their official duties, they are not answerable to any court of law. Which means if a bill is presented to the president or the governor for signature, you cannot challenge it on the ground that why did president sign it? Why did governor sign it? Why did governor not sign it? So when they discharge their official duties, they cannot be held accountable in any court of law. Why? Because in England, we say we have to prevent the dignity of the office of the king. King should not be dragged to the court. Second, no criminal action whatsoever can be initiated against the president or the governor as long as they remain in office, because the king does no wrong. For example, Mr. Kalyan Singh, Mr. Kalyan Singh was the chief minister of Uttar Pradesh when Babri Masjid was demolished. There was a petition pending in the court already that the government should take steps to protect Babri Masjid from getting demolished. Mr. Kalyan Singh, as the chief minister, had given an assurance to the Supreme Court that nothing will happen to the mosque, we will protect it. But ultimately, the mosque was destroyed. And then there was a case against Kalyan Singh calling for criminal conspiracy. That means he was responsible for this conspiracy to commit a crime, and the crime was demolishing a mosque. This case continued, and then Mr. Kalyan Singh was appointed as the governor of Rajasthan. Once he was appointed as the governor of Rajasthan, the case stopped. Why? Because no criminal action whatsoever can be initiated against the president or the governor while they remain in office. Once Kalyan Singh's 5-year term as the governor got over, after he demitted the office of the governor of Rajasthan, then action was taken against him. Then the case continued against him. But later on, he was acquitted by the court. He was set free by the court. But the point here is, the office of president or the governor, when we say nobody is above the law, It is not an absolute fundamental right. Why? Because there are some people who appear to be above the law. President or the governor, when they discharge their official duties, they are not held answerable in any court of law. Sir, isn't that blatant? No. Why? Basically, we will discuss later on, president is a rubber stamp. President does not have the power of his own. Basically, it's the prime minister and his council of ministers who are asking the president to sign a particular bill, to take a particular decision, to sign a particular action. So president cannot be held accountable for the decisions, for the actions of his ministers, for the action of the prime minister. Hold them accountable, not the president, because president does not have the real power. But to preserve the dignity of the office, we say that no criminal action can be taken against the president or the governor while they are in office. But after they demit the office, action can be taken against them. Third, visiting heads of countries and foreign diplomats, they are not answerable to the courts of India in discharge of their official functions. There is something known as Vienna Convention. (1961), which is a product of Cold War. What is this Cold War? You will discuss in international relations, but very briefly here. After the Second World War, the world became bipolar. Two superpowers emerged, United States and USSR, which is today's Russia. There was a lot of animosity between the two countries. Lot of animosity. And we said that there was a period of Cold War. That means although not a single bullet was fired, not a missile was fired, but it appeared that the hostility between the two countries was at so high level that any time war can break out. And it was in this period that United States, when United States would see diplomats of USSR in other countries, they would kill them. USSR would also see the diplomats or the spies of US in other countries, they would kill them or torture them. So that means the diplomats of United States in countries which were friendly to USSR, they were threatened that at any point in time they can be arrested. They are doing their duty, but they can be arrested. Similarly, the diplomats of countries which are close to USSR, they would feel threatened in the countries which are closer to United States. That means, for example, a Russian diplomat in Britain may be accused of spying and then will be arrested. In this atmosphere, the diplomats, the foreign officers, cannot be able to discharge their duties. They will always be under this fear that at any point in time they can be arrested. And that is how a convention was signed, known as Vienna Convention on Diplomatic Relations in 1961. According to this, diplomats posted in foreign countries, they cannot be arrested by the host country. Which means if there is a Pakistani diplomat in India, no matter what this Pakistani diplomat does in India, cannot be arrested. No action can be taken against him. In fact, the Pakistani embassy in New Delhi, the police, the army, any other entity in India cannot enter that embassy without the permission of the head of the embassy. That means unless and until Pakistani High Commissioner says and tells, gives permission to the police and the army to enter Pakistani embassy, they cannot do that. In fact, this protection is extended to the private residence of the diplomats as well. Tomorrow, once you clear this exam, some of you may become IFS officers and you are posted in Pakistan. There you have a private residence. That private residence is inviolate. What is inviolate? That means the police, the army, no other entity of the host country, Pakistan, can enter your private residence without your permission. And this is to ensure that these foreign diplomats, they do their job, They do their service without any fear, without any threat, without any coercion. That means these foreign diplomats, once they are posted in India, they can commit crimes after crimes and no action can be taken against them. When we say everybody is equal in the eyes of the law, there are some exceptions. Exceptions because we are a signatory, we are a party to this Vienna Convention. But there is one option available with the state, with the host country. For example, India. Pakistani High Commissioner is committing murder after murder in India. We can't take any action. Committing rape after rape. We can't take any action. Is using money to fund separatist elements in India, terrorists in India. We can't take any action. No, we can take one action. And what is that action? India can declare that that diplomat is persona non grata. Persona non grata, which basically means time period will be given to that diplomat, that within this time period you have to leave this country. If you don't leave this country, we can arrest you. What is the difference between High Commissioner and Ambassador to any country? High Commissioner is basically the head of Foreign Office in India of a country which is part of the Commonwealth. For example, Commonwealth is an entity which basically is a group of countries which were previously under the British Empire. Those are what we call Commonwealth. For example, Australia, for example, New Zealand, for example, Canada. These are the countries which are part of the Commonwealth. All the heads of these countries who are in India, all the foreign diplomats in India, the head of the foreign diplomacy in India of these countries, we call him High Commissioner, or we call her High Commissioner. Ambassador is from a non-Commonwealth country. That's the difference. Okay, so Article 14, Part 1, the state shall not deny to any person equality before law or equal protection of the laws within the territory of India. And what is equality before law? It's a negative concept which we have borrowed from the English Constitution, borrowed from England. It basically is a corollary of rule of law, which basically means no person shall be made to suffer in body or goods except for a breach of law. Any person can sue or be sued. To put it simply, there are no special privileges no matter who you are. Everybody will be subjected to the ordinary law of land. No special law for different communities. And nobody is above the law. But even this fundamental right, equality before law, is not absolute, which means there are exceptions, which means we can say there are some persons who are above the law. President or the governor, when they discharge their official duties, they cannot be held answerable in any court of law. President or the governor, no criminal action whatsoever can be taken against them while they are in office. And the visiting heads of countries and foreign diplomats, they are not answerable to the courts in India in discharge of their official functions. But what is equal protection of the law? We say as a concept, we have borrowed it from United States. And we say it is a positive concept. And what is that positive concept? Look at this image. There is a baseball match going on. And there is this person A, B, C. Clear? Who is watching them? State. Who is the state? Definition under Article 12 of the Constitution. State is watching them. This person A, is he able to watch the match clearly? Yes. Person B? Yes. Person C? Absolutely not. He's trying to sneak through the gaps to watch this match. Who is a witness to this? State. Is the state interfering? No. Is the state interfering? No. Let them decide on their own. what they want to do, how they want to do it. We will not interfere. Is this equality? Yes, it is. Because what is equality? Treating everybody equally. The state, by not interfering in this situation, is treating A, B, C equally. This is what we call equality. But is this justice? No, it's not. We need to ensure substantive justice. What is that substantive justice? The state has to have an affirmative action policy. The state cannot act as a mute spectator and see this injustice going on. The state has to interfere. Normally we say in fundamental rights, these are restrictions on the powers of the state. State, don't interfere. But equal protection of the law is a positive concept. We have borrowed from the US, where we are asking the state, please interfere. Something unique in fundamental rights, please interfere so that you provide substantive justice to these people. So that real justice is provided, so that everybody is able to watch the match. And what the state does? State now interferes. Snatches something from A, gives it to C instead. This is what we call distributive justice. Distribute the resources that the state has. Give something to somebody, give something more to somebody, give nothing to somebody, depending upon what is their status in the society. That is distributive justice. And it is this equality plus justice, which is what we call equity. This is what is equal protection of the law. And now maybe you would be able to relate it to something. A reservation system in India. There was a time when Dalits, they were forced to move out of schools. You can't go to a school. There was a time when even Sanskrit education was reserved only for Brahmins. With no offense to Brahmins, this is part of the history. Whether that is true or not, I was not born. So don't lynch me for that. I've just read a few books. There they mention this. That's all. When they were not given access to school, which means they started doing those menial jobs. To clean the dirt, to clean your septic tank, to clean your floor. That is how, although originally it was meant to be division of labor, but now it became a profession by birth. Now the son of a cobbler will remain a cobbler. He will have no access to school. If you have watched that movie Swades, where there was one, I think, ironsmith, he wanted to shift to agriculture, farming. He was not allowed. He was boycotted by the village. Why? Because how can an ironsmith change his profession? Because that profession is given to you by your birth. Such was the inequality. Now, after the independence, after the commencement of the constitution, when we have opened up educational opportunities to everybody, how can the students or the children of the Dalit communities or the tribal communities compete with the so-called upper castes? They are not equal in the first place. So we can talk about equality when all these individuals are equal. First, we have to lift them up, give something to them. That is what we call the affirmative action policy. Distributive justice. Substantive justice. We have to give them reservations so that they can uplift themselves. Then we can talk about equality. So reservation is possible because of Article 14 of the Constitution. Because Constitution says, if you treat everybody equally, It may result in an unequal treatment. Like should be treated alike. That means if you are a murderer, I am also a murderer. Whether you are a Dalit or I am a Brahmin, whether you are a Hindu or I am a Muslim, doesn't matter. We both will be subjected to the same law. Like should be treated alike. But can a murderer be equated with a thief? Both are horrible wrongs. Theft is also a crime. Murder is also a crime. But when we look at the degree, you can't be killing everybody. That means the state cannot award death punishment for the murder as well, for the theft as well. Theft may be given few years in jail. You can't say, sir, I am also a criminal. He's also a criminal. I have committed murder. He has committed theft. We both should be sentenced to death. Otherwise, we both should be sentenced to 2 years in jail. No, we have to treat you differently because you are not alike. You are different. We have to treat those who are in equal, those among the equals, the law should be equal and equally administered. That means like should be treated alike. That is equal protection of the laws. And it is possible in India. Look at the taxation system in India. There is no tax for a segment which is earning up to 2.5 lakh rupees. After that, there is a 5% tax. Then there is a 10% tax. Then there is a 20% tax. Then there is a 30% tax. Then there is a surcharge as well if you're earning more than 50 lakhs. Then there is another tax if you're earning more than 1 crore. Then there is another tax if you're earning more than 5 crore. So progressively as your income goes up, there is more tax that you will have to pay. Is that not violative of equality? Mr. Ambani will say, why are you taxing me more as compared to a shopkeeper? We are both doing business. This is violative of the principle of equality because everybody is to be treated equally. That's what equality principle is. No, like should be treated alike. Mr. Ambani, you will be clubbed with Mr. Adani. And instead of giving you less tax, we will waive off your loan instead. But that was a humorous side, a different matter altogether. The point is, like should be treated alike. Progressive taxation is one example. Armed forces are allowed to possess and consume liquor in prohibited areas. Why? Because they have to be in high spirits if they have to defeat China and Pakistan. Others cannot. So all these different treatments that are given to different sections of the society, it is basically to ensure likes are treated alike. Those who are in similar circumstances should be treated similarly. That is equal protection of the law. And that is Article 14 of the Constitution. Any question? Sir, I don't. Sir, but A, B, C are breaking law by watching match without ticket. How do you know that? This is just an example, my dear. Any standard period for persona non grata, that's for the government to decide. Government can give for 24 hours, 48 hours, any period, 7 days. Sir, aren't personal laws violative of Article 14? We will discuss all these things one by one. Sir, will you discuss procedure established by law in Article 21? Can civil proceedings be filed against the president? Yes, after 2-month notice. Okay. Let's look at Article 15 of the Constitution. And in Article 15, there are 6 clauses 1, 2, 3, 4, 5, 6. We'll discuss all the clauses one by one, but you don't have to remember these clauses. Just understand the concept behind Article 15. Article 15, Clause 1, the state shall not discriminate against any citizen. Now it is clear that Article 15 is exclusively for citizens. The state, under Article 12, shall not discriminate against any citizen on grounds only of religion, race, caste, sex, place of birth, or any of them. The state shall not discriminate against any citizen only on the grounds of religion, race, caste, sex, place of birth, or any of them. That means, can the state discriminate? Yes. But on 6th ground, 7th ground, 8th ground, nth ground. Only on the grounds of religion, race, caste, sex, place of birth, there can be no discrimination. Can there be discrimination? Yes, but on other grounds, other than these 5 mentioned under Article 15. For example, you appear or you want an admission in, let's say, Jawaharlal Nehru University, International University. Is it? You want an admission in JNU. JNU is not giving you admission. Is JNU a state within the meaning of Article 12? Yes, because it is funded by the state. It's a state university. It's a state under Article 12. You go to the court, directly the Supreme Court. Why? Because the Supreme Court is the protector of your fundamental rights. If your fundamental rights are violated, you can directly approach the Supreme Court. You ran towards the Supreme Court. My lord, my fundamental right has been violated. Justice Chandrachud says, please come here. I'm your protector. Which fundamental right is violated? My lord, Article 15. Said, why? Because I belong to Sikh religion. JNU is not giving me admission. Really? JNU Vice Chancellor, come here. Why are you discriminating against him on the grounds of religion? Or somebody says, someone else also comes. I have been discriminated because of my race, because of my caste, because of my sex, because of my place of birth. Because I belong to Northeast and we are not treated like Indians in mainland India, unfortunately. We are called Chinese. We are called different names. Despite the tall claims that we are an integral part of India, we're not treated well. And just because of my place of birth, I was denied admission in JNU. JNU Vice Chancellor, come here. How dare you? JNU Vice Chancellor says, yes, we have discriminated against them. But not on the basis of the fact that he belongs to a particular religion. I discriminated against him on the grounds of age. We have a minimum age requirement. You should be 18 years. He is an infant. Or 10-year-old. Or 15-year-old. That means, yes, he is from a particular religion. But that's not the ground on which we discriminated against him. We did not discriminate him only on the grounds of religion. We discriminated him against the ground of age. Or we discriminated him against on the merit. Yes, we did not provide admission to this particular individual from Northeast, not because of his place of birth, but because he failed to qualify the entrance examination. Merit has to be recognized. On that ground, we have not provided him admission, not because he belongs to a particular place. That means the state can discriminate, but only on the grounds just because you're from a particular religion, race, caste, sex, place of birth. No, there can be no discrimination. If at all there is discrimination, there must exist a sixth, seventh, eighth, ninth, nth ground on the basis of which valid discrimination can be made. In this Article 15, Clause 1 is enforceable only against the state, not on other individuals. If the state is discriminating against you only on these grounds, then you can drag the state to the court. But Article 15, Clause 2 begins with a different wording. It says, no citizen shall, only on the grounds of religion, race, caste, sex, place of birth, or any of them. That means this fundamental right is enforceable against individuals as well. Otherwise, Article 15, Clause 2 would have mentioned the state shall not discriminate. But here, Article 15, Clause 2 is saying no citizen shall only on the grounds of religion, race, caste, sex, place of birth be discriminated against. How? There was a time when untouchability was at its peak in the pre-independent India, in the pre-constitutional India. Separate wells for separate communities. There used to be social boycott of people belonging to the Dalit communities. You could not access the burial grounds, bathing ghats, cremation grounds. You could not access the means of entertainment. Again, that movie, Swades. That is why it was a very good movie, one of the best Shah Rukh Khan movies of all time. And it was a social commentary. They're watching a play, but those who belong to so-called lower castes, they are watching this from the other side. But at least they're made to watch in that movie. Otherwise, they were not allowed to watch. And that is what the Constitution tries to prohibit, abolish, eradicate this menace of untouchability. If in Article 15, Clause 1, we say the state shall not discriminate against any citizen only on the grounds of religion, race, caste, sex, place of birth. Now 15 Clause 2 is our fight against untouchability. We are saying no citizen shall be discriminated only on the grounds of religion, race, caste, sex, place of birth. When this individual is trying to access public property, when this individual is trying to access public transport, when this individual is trying to access public restaurants, when this individual is trying to access public means of entertainment, bathing ghats, burial grounds, cremation ghats, so on and so forth. That's Article 15, Clause 2. But here, can the state or can others discriminate? Yes. But not only on the grounds of religion, race, caste, sex, place of birth, but on other grounds. What are these other grounds? Other grounds may be medical grounds. My lord, my fundamental right has been violated. Justice Chandrachud, please come. I am your protector. Tell me, who has violated your fundamental right? The people of my village. Why? I went to a well to get water. They are not allowing me. So to access public property, they are discriminating against me because I belong to the Dalit community. I said, really? This is a violation of fundamental right? Bring these people here. How dare you violate the fundamental rights of this individual? Sir, we have not violated. He's lying. He's suffering from COVID-19. We want him to be quarantined inside home. Otherwise, he will spread this menace to other members of the village. That is the reason we did not allow him to fetch water from that well. Not because he belongs to a particular caste, but because of his medical condition. Similarly, with people who are suffering from leprosy, there are separate colonies for them. Otherwise, they will spread this disease. On medical grounds, there can be discrimination. On age, there can be discrimination. On some other factors, there can be discrimination. But not only on the grounds of religion, race, caste, sex, place of birth. But when we say there can be no discrimination only on the grounds of religion, race, caste, sex, how is it that women's reservation bill is passed by the parliament reserving seats for women in Lok Sabha and legislative assemblies only on the grounds of sex? How is it that not less than 33% of seats in panchayat and municipalities are reserved for women just because of their sex? How is it that there are so many schemes which are specifically for children, specifically for women? You're a woman, you want to give birth to a child, the employer has to give you 6 months of paid maternity leave under the Maternity Benefit Act. What does the husband get? 7 days, 15 days maximum. Is that not discrimination only on the grounds of sex? Yes, it is. But is it allowed? Yes, it is. How? Because Article 15 is not absolute. Article 15 comes under exceptions as well. And what are those exceptions? Nothing in this article shall prevent the state from making any special provision for women and children. Nothing in this article. What is mentioned in this article? That the state cannot discriminate only on the grounds of sex. But that does not apply if the state wants to make special provisions for women and children. So the exception to Article 15 is special provisions can be made for women and children. Something else. This example that we have discussed yesterday, Madras government. It was then Madras, it's today Tamil Nadu. Madras government in 1951 issued an order calling for reservation, providing reservation for SCs and STs in government engineering and medical colleges. Matter went to the court. What was that case? Anyone in the comment section? Champak Dorai Rajan versus State of Madras. The Supreme Court said, what is this order of the Madras government all about? Madras government said, sir, we are providing reservation for SCs and STs in government engineering and medical colleges. The Supreme Court asked, on what grounds? Why? What is the logic? What is the rationale? Madras government said, we want to implement directive principle of state policy, particularly Article 46, which we will discuss in DPSP. Article 46 basically says there will be claims by the members of the SC and ST community in government jobs and in educational institutions. The state has to listen to these claims. Madras government said, my lord, we are implementing Article 46, which is a directive principle of state policy. That is why we want to provide reservation in government engineering and medical colleges to the members of SC and ST community. Supreme Court said, but DPSPs are inferior to fundamental rights. Fundamental rights are superior. DPSPs are inferior. Even if you want to give implementation to DPSP, you cannot dare violate fundamental rights. And how dare you violate Article 15? Article 15 clearly says the state shall not discriminate against its citizens only on the grounds of caste. So how can on the grounds of caste can you provide reservation in engineering and medical colleges? This is not allowed. This Madras government order is unconstitutional, violative of Article 15 of the Constitution. The government said, what do we do? Parliament got together. Parliament decided, no, we'll have to provide reservation to SCs and STs. For that, what we will do? We will amend the Constitution. Constitution was amended for the first time. The year was 1951. The first Constitutional Amendment Act, 1951, added Article 15, Clause 4, which basically means another exception. If the state shall not discriminate against its citizens only on the grounds of sex, an exception is for women and children, special provisions can be made. If under Article 15 there can be no discrimination on the grounds of caste, another exception is made, Article 15, Clause 4. This means that nothing in this article shall prevent the state from making any special provision for the advancement of those who are socially and educationally backward, which means the members belonging to SC and ST community. Nothing in this article, because this article says there can be no discrimination on the grounds of caste. This restriction does not apply if the state wants to make any provision. And any provision means reservation. If the state wants to make any provision for the advancement of those who are socially backward, who are educationally backward, for example, SCs and STs. What is this social backwardness? What is this educational backwardness? The society, unfortunately, was divided into some form of a Chaturvarna system, with Brahmins at the top, Shudras at the bottom, Dalits outside it, untouchables, so-called untouchables. Mahatma Gandhi called them Harijans, the children of God. Constitution called them scheduled castes. Nothing in this article shall prevent, if you want to make any special provision for socially and educationally backward class of citizens. Socially, they were backward. And when they were backward, they did not have access to education as well, which means they were not allowed entry into the schools. Or they were tortured in the schools so that they come out of schools. They drop out of the schools. Because of this discrimination, they became socially backward, educationally backward as well. And for them, special provision can be made by the state. For example, the reservation of seats. This was added to the Constitution by the first Constitutional Amendment Act, 1951, Article 15, Clause 4. And it was this article which was used to reserve seats in educational institutions. Educational institutions, but primarily government educational institutions. But as the things passed and progressed, we saw the emergence of the private sector. We saw the emergence of the private educational institutions. We saw the mushrooming of the private educational institutions in India. Now the question was, the demand was, that since private educational institutions are also increasing day by day in India, they provide educational opportunities to a massive audience in India. We need reservation there as well. Not just in government colleges, government universities, but in private educational institutions as well. And for that, we have a private educational institute. We can divide private educational institute into two. Those which are aided those which are unaided. I don't know whether you would have noticed this, but normally in the local newspapers, when you read the newspaper specific to a particular state, not the national newspaper, you will see the advertisement of the colleges or universities or schools saying aided institution or unaided institution. Aided by the state. That means some funds are allocated by the state to these institutions, even if they are private. So we have educational institutions. Either educational institutions are government, where reservation extends, is present, or we have private educational institutions. In private educational institutions, there can be aided institutions which are aided by the state. There can be unaided institutions which are not receiving funds from the state. And then we have another group of institutions known as minority educational institutions, which we will discuss in great detail under Article 30, but very briefly here. There are religious minorities in India. For example, Muslims, for example, Sikhs, for example, Christians, for example, Jains, for example, Parsis, for example, Buddhists. If they set up their educational institutions, those are minority institutions. For example, St. Stephen's College, Aligarh Muslim University, the Khalsa schools, Jamia Millia Islamia, all these are minority educational institutions. The demand was that we should extend reservation, which is currently only in government educational institutions, to all other institutions. And for that, the law was passed again. The constitution was amended again. 93rd Constitutional Amendment Act, Article 15, Clause 5 was added to the constitution. And what did this article say? That there can be seats reserved in favor of those who are socially and educationally backward in all institutions, whether government or private, in private, whether aided or unaided. And the only category of educational institution which is kept out of the reservation system are those which are the minority educational institutions. Then came 2007. And in 2007, a law was passed known as Central Educational Institutions. There are central educational institutions, for example, IITs, for example, IIMs, for example, NITs. Central Educational Institutions, Reservation of Seats Act 2007. Says why only SCs and STs? 27% reservation shall be provided to OBCs, other backward classes as well, in these central institutions. But there are some purely research-based institutions such as Tata Institute of Fundamental Research, which has been kept out of the reservation system. It's purely research-based. Then came 2019, where Constitution was enacted again, amended again. 103rd Constitutional Amendment Act was passed. Article 15, Clause 6 was added. According to this clause, why only socially and educationally backward, which means SCs and STs? Why only OBCs? Why not those who belong to EWS? Economically weaker sections of society. For them also, there shall be seats reserved. Which means, long story short, if we need to summarize Article 15, we can say Article 15 has various clauses, but you don't have to go by clause or remember clause by clause, just understand the concept. Concept number 1 is the state shall not discriminate against any citizen only on the grounds of religion, race, caste, sex, place of birth, or any of them. which means the state, if it wants to discriminate, there must exist other grounds other than those mentioned in the constitution. And even the individual citizens cannot discriminate against fellow citizens only on the grounds of religion, race, caste, sex, place of birth when these individuals want to access public property, burial grounds, cremation grounds, bathing ghats, so on and so forth. But even this fundamental right is not absolute. Exceptions. Exceptions are women and children. Special provisions can be made for the advancement of women and children. Exception is SCs and STs. Seats can be reserved for them in government, engineering, and medical colleges, then in government colleges, all government colleges. Then the demand came, why only government, why not private? Said, okay, let's extend the reservation to all government, to all private institutions, whether aided or unaided, except the minority educational institution. Then the demand came from OBCs, we need reservation as well, reservation for you as well, in all institutions, 27%. Then why only SCs and STs and OBCs? Why not economically weaker sections of the society? Mr. Modi said, Mitro, for you as well, reservation of seats in all institutions except minority educational institutions for those who belong to economically weaker sections of the society. All these are exceptions, Article 15 of the Constitution. Any question as of now? Is discrimination always unfair? Negative discrimination is unfair. Positive discrimination is fair. Positive discrimination, for example, reservation system. Positive discrimination, for example, scholarships. Positive discrimination, for example, loans at cheaper prices. Kajal, your questions are reaching, but what is your question? What if general are economically weak? Jia, that is why Article 15 says, for the advancement of any economically weaker sections of the society other than those classes mentioned already. That means these economically weaker sections of the society should not be SCs, STs, OBCs. They should not be benefited under the current reservation system. So if you are economically weaker section of the society, you should be from the general category. Because OBCs already have reservation, SCs already have reservation, STs already have reservation. EWS is for general category. Can Byju's discriminate on the grounds of Article 15? Under Article 15, yes, we can discriminate, but not if you want to access public property, burial grounds, cremation ghats, a means of entertainment, shops. We can't do that. Sir, if politician can misuse constitutional provision by increasing reservation, remove that politician. Don't vote for that politician or the political party to which he represents. Because ultimately, sovereignty lies with the people, with you. Now, whatever doubts you may have would become clear. Doubts related to reservation would become clear when we will discuss Article 16. Hold your horses, stay calm, listen to me. When I will ask you, when I will tell you that ask me questions if you have any, then start asking questions. Till then, be patient, calm, just listen to me, just write down whatever I'm saying. I'm sure after this topic is over, there won't be questions left on your mind vis-a-vis with respect to reservations. Article 16 again has various clauses. Clause 1, 2, 3, 4, 5, 6. But you don't have to remember clauses. Just understand the concept. Article 16, Clause 1, it says there shall be equality of opportunity in public employment for all the citizens, which means this Article 16 is also exclusively available to citizens. Equal opportunity should be provided to all the citizens when the government is advertising posts, when the government is inviting applications for government jobs. There should be equality of opportunity. How? Article 16, Clause 2 says, no citizen shall, on grounds only of religion, race, caste, sex, place of birth, residence, descent, or any of them, be ineligible for or discriminated against in respect of any employment or office under the state. State under Article 12. Which means when the state is inviting applications for government jobs, for example, state is UPSC, Union Public Service Commission. It is inviting applications. All of you who want to write the civil services examination may write. But is this exam only for Hindus and not for others? No. Is this exam only for the Dravidian race and not for the others? No. Is this exam only for the general category and not for SCs, STs, OBCs? No. Is this exam only for females and not for males? No. Is this exam for those who are only the citizen of India by birth and not to those who are the citizens of India by descent? No. This is for exam for every citizen, whether by birth or by descent or naturalization, whatever. Is this an exam only for those who are born in the states which are under North India and not in the states which are under South India? No. Is this exam only for those who are now residing in North India and not in South India? No. That means on these grounds there can be no discrimination. Only on these grounds there can be no discrimination. That means, can the state discriminate? Yes. But on 8th ground, 9th ground, 10th ground. In Article 15, there are 5 grounds on the basis of which there can be no discrimination. In Article 16, there are 7 grounds. On the grounds of religion, race, caste, sex, place of birth, descent, residence, there can be no discrimination only on these grounds. But can there be discrimination? Yes. On what ground? Age. My lord, my fundamental right has been violated. Come here. Who violated your fundamental rights? UPSC. How? They released a list of successful candidates who cleared the civil services examination, which is basically a government post, a government job. My name is not there in the list. Just because I am from particular religion, race, caste, sex, place of birth. Really? UPSC, come here. Why have you discriminated against this individual? Said he was not eligible. I told him you are from general category. Your age is 35. But for general category, the age limit is 32. What should I do? This person is ineligible. Said, okay, you're discriminating on valid ground, age. Merit. Why have you discriminated against him? Sir, what should I say? Say something. Why have you discriminated against this person? He could not qualify prelims. And now he claims that I should become an IS officer. Should we discriminate others who cleared prelims, mains, personality test and topped this exam? And we will give this person a job? On merit, we are discriminating against him. Quite fair. Sir, but me. Oh, you come here. Sir, I cleared prelims, mains, personality test as well. Still, they have denied me a job. I said, why? But what about this person? He has cleared prelims, mains as well as the personality test. Why are you discriminating against him? Sir, on medical grounds. This person is not medically fit to be part of the services. Why? What is wrong with him? Sir, he wanted to become an IAS officer, but he is suffering from flat foot. And we have mentioned it in our medical guidelines that person suffering from flat foot cannot become an IPS officer. So yes, he is right. He cleared prelims, mains, personality test, but on medical grounds, PAVE discriminated against him. That means there can be other grounds on the basis of which the state can make valid discrimination. But only on the grounds of religion, race, caste, sex, place of birth, descent, residence, there can be no discrimination whatsoever. But just like Article 14, just like Article 15, Article 16 also is not what it is not absolute, which means there are exceptions. What is an exception? Article 16, Clause 3. What is an exception? It confers the power on the parliament that what parliament you can do, you can pass a law. Through this law, what you can do, you can provide residence as a qualification for some jobs. Can there be discrimination on the grounds of religion, race, caste, sex, place of birth, residence, descent? No. Can religion, race, caste, sex, place of birth, descent, residence be made qualification? Just because you are from a particular religion, you are ineligible to write this exam. Just because you are from a particular residence, you are ineligible to write this exam. Can this happen? No. Can this happen then? Yes. Why? Because there is an exception. What can happen? Parliament may by law. What Parliament can do, it can pass a law. And through this law, what it can do, it can provide residence as a qualification for certain classes of employment under the state. One example, Article 371, capital J, which talks about Hyderabad, Karnataka region, 6 backward districts of Hyderabad, Karnataka region, for example, Gulbarga, Raichur, Bidar, Bellary, so on and so forth, 6 backward districts. Here, if you want a job, the State Public Service Commission in Karnataka, the Karnataka Public Service Commission, when it would advertise jobs, it would say that jobs in these 6 districts shall be reserved for those who are the residents of these 6 backward districts. That means residence becomes a qualification for a job. Those who are the residents of other districts of Karnataka, they are ineligible to get these jobs. Similar to something like Mulki rules or Mulk rules, which used to happen in Telangana, Hyderabad region. During the Nizam's time, there were some jobs which were reserved for those only for those who were the residents of Telangana, who were the residents of Hyderabad. When Nizam gave his power, Hyderabad became part of India. One of the condition was that these jobs will continue to be reserved for those who are the residents of Hyderabad. That means residence can be the qualification for certain jobs. The government of India said, no issues, we will have an exception in the constitution that if we want, which means the parliament, that means state legislature cannot. Legislature of Karnataka, legislature of Andhra, legislature of Telangana, legislature of UP, they cannot say that from now onwards, these jobs are reserved for those who are the residents of our states. No. Parliament alone can do that. Parliament has that power. Parliament can, through law, for example, Article 371, capital J, provide for residence as a qualification for certain jobs. And these jobs will only be for state appointments, not union appointments. For example, 371 capital J. Who introduced this article in the Constitution? Parliament, not the state legislature. According to this article 371 capital J, what will happen? 6 backward districts of Hyderabad Karnataka region. Jobs in these 6 backward districts will be reserved for those who are the residents of these 6 backward districts. But this is applicable only for state jobs, not the union jobs, not the jobs at the central level. So at the central level, Parliament cannot say residence is a qualification, is eligibility to get a government job. No, only at the state level, the Parliament may do that. That is exception. So Article 16, which says equality of opportunity in public employment, equality of opportunity in government jobs. There can be no discrimination only on the grounds, 7 grounds mentioned in the Constitution. But there is an exception. Residence can be a qualification as well. But who can prescribe residence as a qualification? Not the state legislature, but the Parliament. Otherwise, every state legislature will pass a law and say only those who are the residents of UP are eligible for job in UP. Only those who are the residents of Andhra are eligible for a job in Andhra. Only those who are residents of Haryana are eligible for job in Haryana. That would have happened. But this is something that can be done only by the Parliament, not the state legislature. Clear? Something else. Article 16, Clause 4, another exception. The state is empowered. What state you can do? You can reserve seats. For whom? For those who are socially and educationally backward. Who are these socially and educationally backward classes of citizens? SCs and STs. What will you do? You will provide them reservation, provided they are not adequately represented in the services under the state. Article 16, Clause 4 creates another exception. The state is empowered. That what the state you can do, you can reserve seats. For whom? Those who are socially and educationally backward, which means SCs and STs. Where? In government jobs, you can reserve seats for them, provided they're not adequately represented in the services. Adequately represented, for example, their population is 20%, but only 2% of their community, they are the members of the state. They are part of the services of the state. They are part of the government jobs, which means they are not adequately represented. But Article 16, Clause 4 was used to provide reservation for SCs and STs in various government jobs in India. Then came emergency. In 1975. And this emergency was lifted in 1977. And in 1977, Janata Party came to power and Shri Morarji Desai became the Prime Minister of India. And then the government set up a committee headed by Mr. B.P. Mandal, a politician from Bihar. This commission came to be known as the Mandal Commission. What was the purpose of this Mandal Commission? The government asked Mr. B.P. Mandal, please come here. He said, what? There are SCs and STs. I said, yes. They are socially and educationally backward. We call them socially and educationally backward. That is why we have a reservation for them in educational institutions, in government jobs as well. I said, yes. Now, apart from SCs and STs, can you identify other communities who are also socially and educationally backward so that we can provide them some benefits as well? Maybe we can provide them reservation as well. Mr. Mandal said, sure, sir, I'll submit a report. BP Mandal submitted a report and said 52% population other than SCs and STs, they are also socially and educationally backward. And BP Mandal Commission said we will call them OBCs. What are OBCs? Other backward classes. That means they are backward classes, but other than SCs and STs. And Mandal Commission said for them 27% reservation should be implemented. 27% reservation in government jobs and in educational institutions. This report was submitted, but no action could be taken on this report. After Janata Party lost power, Shrimati Indira Gandhi became the Prime Minister. She did not implement this report. Shrimati Indira Gandhi was assassinated. Rajiv Gandhi became the Prime Minister and then won the election as well. Even he did not implement this report. Rajiv Gandhi got embroiled in a controversy known as the Bofors scam. Where it was argued that to procure these Bofors guns, which played a very important role in the Kargil war. So there was nothing wrong with the guns, but it was the way in which the guns were acquired, in which the deal was done. There was some kickbacks involved, some corruption involved. Rajiv Gandhi was unaccused. Amitabh Bachchan, who was then the member of parliament, member of Lok Sabha from Allahabad constituency, a very close friend of Rajiv Gandhi, was also accused. And others were accused. Kotharachi, various others. We don't have to get into that. The image of Rajiv Gandhi took a hit. So initially he was viewed as very clean politician, technically savvy individual who introduced computers in India. But now his image took a hit. His defense minister was Vishwanath Pratap Singh, VP Singh. He resigned. He then became 2011's Arvind Kejriwal. In a sense, he launched corruption movement against Rajiv Gandhi. He got a lot of support from the people. But then in 1989, when the elections were held, no political party got the majority. VP Singh got the support of various political parties, particularly the BJP and the left parties. Left parties, the Communist Party of India, the Communist Party of India, Marxists, the Communist parties, various Communist parties, Left Front, they supported VP Singh. BJP also supported VP Singh just to keep Rajiv Gandhi out of power. And ultimately, VP Singh became the Prime Minister. But VP Singh realized that very soon I will be kicked out. Why? Because these two ideological opposites, BJP, which is a right-wing political party, Communist, which is a left-wing political association, they are supporting my government will not be long-lived. It will be a short-lived government. But I want to leave my legacy. I want to leave my mark so that people later on will talk about me. And in one fell swoop, what VP Singh government did, implemented the Mandal Commission report. Implemented Mandal Commission report, 27% reservation in government jobs was provided to the members of the OBCs. But BJP was in a fix. Why? Because BJP said, and BJP thought that we are viewed as a right-wing political party with support from the upper castes or the so-called upper castes. But the members of the OBCs, they support other political parties. If they are empowered, what will happen to us? We should not let VP Singh implement this Mandal Commission report. So BJP withdrew support to VP Singh. And BJP went from Mandal to Mandir. To deviate the attention of the people from Mandal, BJP went to Mandir, launched a Ram Janmabhoomi movement for the construction of a mega Ram temple at the then disputed site at Ayodhya. But be that as it may, VP Singh government lost power, VP Singh resigned. But Mandal Commission report was implemented. There were a series of protests in different parts of the country. Delhi University and others, members belonging to the so-called upper caste, they killed themselves, self-immolated themselves, and there were a series of protests, lots of destruction of property. And then when the elections were held, PV Narasimha Rao became the Prime Minister. PV Narasimha Rao said, why only 27% reservation for other backward classes? We will provide 10% reservation to poor belonging to the general category. That means now the demand became and the policy became that there will be reservation in government jobs for SCs, for STs, now OBCs, now 10% seats will be reserved for poor belonging to the general category as well. When all these protests was going on, one lawyer of the Supreme Court, Indra Sani, she was driving through these protests, she saw these protests, and ultimately she approached the court and challenged the constitutional validity of OBC reservation as well as this 10% reservation for the poor. And that case came to be known as Indra Sani versus Union of India, and this is also known as the Mandal case. Now the question before the court was, is this OBC reservation constitutional or not? Is this 10% reservation constitutional or not? And now 9 judges of the Supreme Court are hearing this matter. What did the Supreme Court rule? Supreme Court said, number one, reservation is not a fundamental right. Supreme Court said reservation is not a fundamental right. Why? Because the Constitution says that the state can make any provision for the advancement of socially and educationally backward class of citizens. Any provision can be reservation, any provision can be scholarship, any provision can be fee waiver, any provision can be any provision. It may not only necessarily be reservation. So reservation is not a fundamental right. And this reservation is enabled by Article 16 Clause 4. Because Article 16 Clause 4, what does it talk about? It empowers the state to reserve seats in favor of the backward classes, provided they are not adequately represented in the administration. So there is a condition to provide reservation. And who can decide that? State. That means reservation is at the discretion of the state. If the state wants to give reservation, it can. If the state does not want to give reservation, you cannot force it. It is right to reservation is not a fundamental right. Reservation is at the discretion of the state. And it is Article 16 Clause 4 which enables reservation. Supreme Court further said that this OBC reservation is constitutional. Yes, 27% jobs can be reserved for other backward classes, but for that you have to meet 5 constitutional requirements. Constitutional requirement number 1, prove to us that they are socially and educationally backward. Constitution provides for that there can be reservation of seats. There can be special provision. But for whom? Those who are socially and educationally backward. We have always assumed that SCs and STs are socially and educationally backward. But apart from SCs and STs, if there are others who are also socially and educationally backward, prove to us. Which basically means you will have to set up a commission. This commission will have to study various caste groups, will have to ultimately prepare a report, and basis that report, it has to convince us that all these communities that we are mentioning, they are socially and educationally backward. Prove to us that they are socially and educationally backward. Condition number 2, they are not adequately represented in the administration. Because what does Article 16 Clause 4 say? It empowers the state that you can reserve the seats for socially and educationally backward. So if you are identifying these people as socially and educationally backward, there is another condition, provided they are not adequately represented in the administration. So all these communities whom you are calling socially and educationally backward, if their population is 20%, but in the administration they are 60%, that means they are represented in the administration. Why give them reservation? But if they are not adequately represented, which means less and less number of people from these communities are part of the administration, which means they are not adequately represented, you can give them reservation. But these conditions you will have to satisfy. First, prove to us by setting up a commission so that they conduct a study, so that they present a report, and through this report they say that these are the communities who are socially and educationally backward, and prove to us that these communities are not adequately represented in the administration. Condition number 3, concept of creamy layer shall apply. What is that creamy layer? If this caste group A yes, they are socially and educationally backward. Clear? But there is an individual, or there are individuals belonging to this community but their annual income is 8 lakhs. If they are holders of constitutional office, if their father is a judge, is an attorney general, is a civil servant, if you are holding agricultural land, let's say 5 acres, if you are holding flat in urban area which is more than 1000 square feet, all such individuals, despite the fact that you are from socially and educationally backward community, but you belong to creamy layer. Of this community, you are a cream at the top. Cream is at the top. When you boil the milk, the cream is at the top. So you are at the top of this pyramid. You will not get reservation. Those who are from non-creamy layer, they will get reservation. That means what the court said, OBC reservation which you have implemented is constitutional, is okay. But for that, you have to meet 5 requirements. Prove to us that all these communities whom you are calling OBCs, they're socially and educationally backward. Prove to us that they are not adequately represented in the administration. And these OBCs, some of them may be creamy layer, some of them will be non-creamy layer. Creamy layer, which will have some economic width as well. Those will not get reservation. But those who are from non-creamy layer, they will get the reservation. Fourth, reservation cannot at any point in time exceed 50% except in extraordinary circumstances. If 15% jobs are reserved for SCs, 7.5% jobs are reserved for STs, 27% jobs are reserved for OBCs, reservation under any criteria, under any circumstance, shall not exceed 50%, except in extraordinary circumstances, which we will discuss slightly later. But all this is possible subject to Article 335 of the Constitution. Article 335 says, there will be claims by the members of SC community. There will be claims by the members of ST community. There will be claims by the members who are socially and educationally backward that they want government jobs. Ensure their claims. Take their claims, but subject to efficiency in administration. Merit cannot be sacrificed. Don't flirt with the merit. Merit in the sense, yes, you provide reservation of jobs to SCs and STs, but don't lower the merit to such a level that we need doctors with MBBS degree and you are recruiting people with B pharmacy. Just because you are a member of SC, ST or OBC community, merit should not be sacrificed. That person has to be an MBBS holder. Yes, the percentage of marks can be reduced. For general category, it can be 50%. For reserved category, it can be 40%. But it has to be MBBS. If you satisfy all these criteria, reservation for OBCs is constitutional. The Supreme Court was asked, but sir, what about this 10% reservation that Shri P.V. Narasimha Rao has provided to the poor belonging to the general category? Supreme Court said that is unconstitutional. You cannot provide reservation to poor. You cannot provide reservation to those who are economically weak. Why? Because the Constitution says state can reserve seats only for those who are socially and educationally backward. Is economic backwardness mentioned as a ground under the Constitution under which the state can reserve seats? No. When the Constitution talks about only 2 kinds of backwardness, social and educational, P.V. Narasimha Rao, your order to provide reservation to poor is unconstitutional because Constitution does not recognize economic backwardness. Constitution recognizes only social and educational backwardness. Said, okay, and listen to me, come here. Said what? Reservation can be only at the time of recruitment, not at the time of promotion. So once you're recruiting people, you can reserve seats basis on SCs, STs, OBCs. But after that, you should not have reservation and promotion as well. If you have to promote 10 people, out of these 10 people, 2 people should be from SCs, 3 people should be from STs, 4 people should be from OBCs. No, reservation only at the time of entry, not at the time of promotion. Any question as of now? Sir, please discuss Haryana's 75% reservation. We'll discuss everything one by one. We'll reach there as well. Okay, so let's take a break. We will meet at 8:05. See you on the other side of the break, then we will address all your questions. Article 16 of the Constitution, there shall be equality of opportunity when it comes to government jobs. Constitution says the state shall not discriminate against any citizen on 7 grounds, only on the 7 grounds of religion, race, caste, sex, place of birth, descent, residence. But can the state discriminate on other grounds? But this is not an absolute fundamental right because there are exceptions. Exceptions such as the parliament may prescribe residence as a qualification for some jobs. But these jobs can only be at the state level, cannot be at the central level. And only parliament and not the state legislature can provide residence as a qualification for certain government jobs at the state level. Exception is that the state can reserve seats, reserve jobs for those who are socially and educationally backward, for example, SCs and STs, provided the state thinks that these communities are not adequately represented in the administration. Then what the government decided? The government decided to implement the Mandal Commission report, basis which 27% jobs can be reserved for other backward classes. The government further said that 10% jobs shall be reserved for those who belong to poor communities or poor categories of the general category. Matter went to the court, Indra Sani versus Union of India. In this judgment, the court said, number one, reservation is not a fundamental right. Reservation is at the discretion of the state. If the state wants to provide reservation, it can. If the state does not want to, nobody can force the state from providing reservation. But reservation can be only on the grounds of social and educational backwardness. Economic backwardness is not recognized by the Constitution. So on economic grounds, there can be no reservation. The court further said, reservation can be only at the time of the entry, not at the time of promotion. Can be only at the time of the recruitment, not at the time of the promotion. But the court said reservation for OBCs in government jobs is constitutional provided 5 requirements are met. Requirements: prove to us that these communities whom you call OBCs, they are socially and educationally backward. Prove to us that they are not adequately represented in the administration. And divide OBCs into creamy layer and non-creamy layer. Give reservation to non-creamy layer and not to the creamy layer. Reservation cannot at any point exceed 50%, except in extraordinary circumstances. And reservation is possible subject to efficiency in administration. Don't flirt with the merit. Don't flirt with the efficiency in administration. After this judgment, OBC reservation became possible. But then since the court had said reservation can be only at the time of the recruitment at entry level, not at the time of promotion, Parliament got together, amended the Constitution again. 77th Constitutional Amendment Act, the year was 1995. Article 16, 4 capital A was inserted into the Constitution. And because of this article, reservation in promotion became possible for those who belong to SC and ST community. That means those SCs and STs who are socially and educationally backward, for them reservation in promotion is also possible under Article 16, 4 capital A, because now the Constitution stands amended. This constitutional amendment was challenged in the court, and the Supreme Court finally gave its verdict in the year 2006, M. Nagaraj versus Union of India. Supreme Court said reservation in promotion for SCs and STs is possible, is constitutional, provided you meet 3 requirements. Prove to us that they are socially and educationally backward. Prove to us that they are not adequately represented in the administration. Prove to us that they do not affect the efficiency in administration if these people are promoted. The government said, but sir, we have proved this in the previous case. In Indra Sani case? No. Indra Sani case was about OBC reservation. In Indra Sani case, we did not question reservation for SCs and STs in government jobs because that was provided since the commencement of the constitution. The specific question before us in Indra Sani case was whether OBC reservation is constitutional or not, whether reservation for the poor is constitutional or not. Nobody challenged and questioned SC/ST reservation. We said that there can be reservation only at the time of the entry, only at the time of the recruitment, not at the time of the promotion. Now you are saying that there should be reservation and promotion as well. Now you will have to tell us that these SCs and STs, they are socially and educationally backward. You will have to tell us that they are not adequately represented in the administration. In a sense, if there are 10 people who are to be promoted from, let's say, assistant director to deputy director, from deputy director to special director, from director to the commissioner or secretary or special secretary, you will have to tell us that members of the SCs and STs, they are discriminated against. Although they are recruited, but once they are recruited, they are not promoted because of their caste. Their promotion is stopped because of their caste. Their promotional opportunities are stopped because of their backwardness. Prove to us. And after that, you'll have to ensure efficiency in administration is not affected. You have to have efficient officers running the administration. If you prove this, reservation in promotion is also possible for SCs and STs. Which means the situation now becomes that there is reservation in government jobs for SCs, STs, OBCs, not for the poor. There is reservation in promotion only for SCs and STs, not for OBCs. And OBCs today are demanding that they should also be given reservation in promotion. But as of now, there is reservation only for SCs and STs in promotion, not for OBCs. Something else happened. Jarnail Singh versus Lakshmi Narayan Gupta 2018. This judgment was authored by Justice Rohinton Fali Nariman. And the Supreme Court said, why creamy layer is only for OBCs? Why not SCs and STs? The way you divide OBCs into creamy layer and non-creamy layer, in the same manner, you should divide SCs and STs into creamy layer and non-creamy layer and provide reservation only for those who are part of the non-creamy layer, not the creamy layer. For example, the late Ram Vilas Paswan. He was known as political weathercock. Political weathercock in the sense, in 2004, when the BJP was in power at the center, he realized that the winds are shifting against the BJP, going towards the Congress. He jumped from BJP. He was part of the BJP-led NDA alliance. He jumped from NDA and joined the Congress-led alliance, the UPA, and UPA came to power. Remained part of the UPA, United Progressive Alliance, because a group of political parties, we joined hands with BJP to form the government in 1998, 1999. This group of political parties came to be known as NDA, National Democratic Alliance. But the group of parties which joined the Congress to form the government in 2004, this group came to be known as UPA, United Progressive Alliance. Just like today, this group is known as India, and the other group is known as NDA. Ram Vilas Paswan saw that people still support UPA. He was still part of the UPA till 2009. Won the elections again. Remained with UPA till 2014. But realized that people may vote in Mr. Modi as the Prime Minister. He jumped from UPA, joined NDA. He is known as a political weathercock. He knows for sure which party is going to come to power so that he can join that group and reap the benefits, become the minister. He was always a minister. Why should his son get reservation? Because it leads to a point where, yes, reservation is okay. Reservation is justified for social justice. But within SCs and STs, there is select group of people who get the benefit. I get benefit for reservation. Tomorrow my son would get reservation benefit, then his son, then their daughter, so on and so forth, and this process continues. So this reservation benefit is reaped by only some sections of SCs and STs. Look at the Meenas of Rajasthan. Every single family would have an IAS, IPS, IRS, IFS officer. So Supreme Court said creamy layer should apply to SCs and STs also, and only those who are from non-creamy layer should get reservation. Jarnail Singh versus Lakshmi Narayan Gupta, 2018. Something else happened. Uttarakhand government invited jobs, or should we say invited job applications. So do we have to learn these cases? If we had no need to learn these cases, I would not be discussing, because my intention is not to waste your time and give you the sense of my knowledge. See, I learn and read so many cases, and I should also tell you, look at the kind of questions asked in the exams these days. Cite relevant case laws. Comment on this issue by citing the relevant case laws. These case laws are very important. It will add weight to your answer. Otherwise, you will not get good marks. Uttarakhand government invited job applications. And in these job applications, Uttarakhand government said there will be no reservation in promotion. Matter went to the Uttarakhand High Court. My lord, rights have been violated. I said, what rights? Sir, no reservation and promotion for SCs and STs. How is that possible? Article 16, clause 4, capital A talks about this. How can Uttarakhand government says that for these applications there won't be reservation and promotion? My rights have been violated. Uttarakhand High Court said, no, this is wrong. You're absolutely right. Uttarakhand High Court asked the state, give us data. Uttarakhand government is asking, sir, my lord, what data? Give us this data so that you can tell us that SCs and STs, they are not socially and educationally backward. Because if they are socially and educationally backward, you have to provide them reservation. Prove to us that they are adequately represented in administration. If they are adequately represented in the administration, that means you don't have to provide them reservation. Give us this data, and you should also tell us that efficiency will be maintained throughout. Give us this data. Uttarakhand High Court approached to Supreme Court. Uttarakhand government approached to Supreme Court. Dear Supreme Court, I have a question. I said, what question? Sir, do you remember Indra Sani judgment 1992? Yes, we do. Why? What happened? Sir, do you recall there you said reservation is not a fundamental right? Yes, we said that. Sir, did you say reservation is at the discretion of the state? Yes. Reservation can be provided by the state if at all they want to. Otherwise, they will not be. There is no force because it's at the discretion of the state. Yes. So then why is Uttarakhand High Court asking us to give them data? We have decided as a matter of policy that for these government jobs, there won't be reservation and promotion. How is Uttarakhand High Court demanding data from us? That they are adequately represented, that they are not socially and educationally backward? Supreme Court said no. Uttarakhand High Court order is wrong. Uttarakhand High Court should not have asked for data. Why? Because reservation, we reiterate, is not a fundamental right. Mukesh Kumar versus State of Uttarakhand, 2020. Reservation is only at the discretion of the state. Reservation is not a fundamental right. Something else happened. Maharashtra, for example, there is one caste group known as the Marathas. The government of Maharashtra decided that Marathas should also be given reservation. They should be made part of the OBCs. What Maharashtra government did, they set up a commission known as Maharashtra State Backward Classes Commission. And this commission recommended that Marathas should also be given reservation. Ultimately, Maratha community was given reservation under Maharashtra State Socially and Educationally Backward Act. Why? Because what did Indrasani judgment say? If you are including a group into OBCs, other backward classes, you have to tell us, you have to prove to us by setting up a commission so that this commission can study, submit a report, and through that report, it can tell us that this particular community, which we have included in other backward classes group, this community is socially and educationally backward. Commission was set up by the Maharashtra government. They submitted a report, and through this report, they said that Marathas are also socially and educationally backward. And once they are socially and educationally backward, they should be provided reservation. This Maratha reservation was challenged in the Bombay High Court. Bombay High Court said this Maratha reservation is okay, but the percentage of reservation that you are providing, that percentage is not very good. Limit the percentage. Said why? Reservation, instead of 16%, it should be 12% in education. Instead of 16%, it should be 13% in jobs. Please go ahead, implement Maratha reservation. We don't have a problem, but this percentage should be reduced because it doesn't sound well by looking at the data that you are providing them 16% reservation. We have to provide adequate representation, adequate reservation. It cannot be more, it cannot be less. It has to be adequate. But then this matter went to the Supreme Court. And the Supreme Court said this Maratha reservation is unconstitutional. This Maratha reservation cannot continue. Why? Because Marathas, according to Supreme Court, not me, they are not socially and educationally backward. Why? Because this commission, which said Marathas are socially and educationally backward, one reason that they provided many reasons. One reason that they provided, they said Marathas, predominant occupation of these Marathas, they are the dabbawalas. Who are these dabbawalas? They have the dabbawala business, in the sense they collect the dabbas, the lunch boxes from people, and then they send these dabbas, these lunch boxes to their family members who may be working somewhere, who may be doing a job somewhere. On this dabbawala business, a beautiful movie, Lunchbox, was made, starring the late Irfan Khan, one of the fantastic movies. If you have got time, please watch that movie. Beautiful story. But be that as it may, Supreme Court said if these Marathas are, a large majority of these Marathas, they are dabbawalas, it proves they are not socially backward. The court was asked how. The court said, look at what social backwardness is. Look at what untouchability is, which is a social backwardness. If I am a Dalit, I cannot offer cooked food to a member of the upper caste. I cannot drink water from the member of the upper caste. If these dabbawalas are really transporting food to others and people are accepting these dabbas from them, that means they are not socially backward. If they would have been socially backward, their dabbas would not have been allowed, accepted by the community, which proves that they are not socially backward. When they are not socially backward, why are you providing them reservation? And look at Marathas, close to 33% of the population in Maharashtra. They are in business, they are in politics, They have MLAs and MPs, and they have strong control over the politics of Maharashtra. So how can you say they are socially and educationally backward? Since they are not socially and educationally backward, Marathas will have no reservation in jobs and educational institutions. So okay. Something else happened. What happened? Let's say, for example, UPSC in its civil services examination advertises 1,000 jobs. Clear? Out of which the Supreme Court has said not more than 50%. Reservation cannot exceed 50% under any unless and until there are extraordinary circumstances. Reservation cannot exceed 50%, which means 500 seats will be unreserved and 500 seats will be reserved. Reserved for SCs, STs, OBCs as of now. What if, for example, 100 seats remain vacant? Although it doesn't happen at the UPSC level, but at the state level, it always happens. If there are 10 vacancies for the reserved categories, but the minimum qualification is graduate, maybe we don't get sufficient candidates who are from reserved categories, who are graduates for that particular post. That means we don't get people. That means there are some seats which remain vacant. What will happen to these 100 seats? Will they be merged with the open category or the unreserved category? Or will these 100 vacancies be carried forward to the next year? Initially, the position was that these seats will never be merged with the unreserved category. They will be carried forwarded to the next year. Then they will be carried forwarded to another year. Then they will be carried forwarded to another year. Under no circumstance can it be merged with the unreserved category. These seats will always be filled by the members of those reserved categories. Matter went to the court. The court was asked, my lord, what will happen to the efficiency in administration? Said, what efficiency in administration? Sir, there are some seats which are reserved, but we don't get candidates from those reserved communities, reserved categories. Those seats remain vacant, which means we need these people for job. Otherwise, the efficiency of administration will take a hit. But these seats are not being filled. We carry forward these seats to the next year, then to the next year, then to the next year. Then forever and ever and ever, we want these seats to be merged with the open category, with the unreserved category. Otherwise, efficiency would take a hit. The court said, yes, you're right. Government, what is your take on this? Sir, we need to carry forward this for next years. Okay, you do that, but only for 3 years. After that, you merge these seats with the unreserved category. Sir, come again. What are you saying? If there are seats which remain vacant in a particular year, carry forward them to the next year and see if next year you can fill these seats from the same reserved communities. Then carry forward for 2 more years. That means for total 3 years. After that, we can't wait for long. These vacancies should be merged with the unreserved category so that from unreserved category, we can fill these vacancies. When this judgment was given, Parliament decided to come together. Parliament said, let's come together. Let's amend the constitution again. 81st Constitutional Amendment Act, the year was 2000, Article 16(4) capital B was inserted into the constitution. And because of this constitutional amendment, now these vacant seats will be carried forwarded forever and can be filled only by the reserved categories. Since the Supreme Court had said you can carry forward these vacant seats only for 3 years, After that, it will be merged with the unreserved category. Parliament got together, amended the constitution, and said these seats will be reserved. Even if they remain vacant, we will never merge them with the unreserved category. These seats will only and only be filled by the members of those communities. That is what we call carry forward policy. Something else happened. Article 16, Clause 5. Let's say, for example, we have a Waqf board. Or for that matter, we have TTD, Tirumala Tirupati Devasthanam, which is a Hindu temple, a Hindu religious place. Who will manage this Hindu religious place? Can a Muslim IAS officer be appointed there? Can a Christian IAS officer be appointed there? No. If it is a religious place, a religious institution, Constitution says that the member, the individual responsible for managing this religious institution can belong to the same religion. Because Article 16 says there can be no discrimination. The state cannot discriminate only on the grounds of religion. But this is not an absolute fundamental right. There is an exception. If the state has to appoint somebody to the Waqf board, what is a Waqf board? All the Muslim mosques, shrines, dargahs, they are managed by this Waqf board. The government appoints officers to this Waqf board. And this appointment can be only of Muslims. That means religion is a qualification in order to be appointed to the Waqf board. And who will appoint you? Government. That means, is the government not discriminating only on the grounds of religion? Yes, but this is an exception. Because appointment to a religious organization can be made of a person professing that particular religion or belonging to that particular religious denomination. It won't be a violation of fundamental rights. But something else happened. 2018, just like in 2023, now elections were held to some states. 3 states were very important: Rajasthan, Chhattisgarh, and Madhya Pradesh. And in all the 3 states, the BJP lost power. Ashok Gehlot became the chief minister of Rajasthan. Mr. Kamal Nath became the chief minister of Madhya Pradesh. And who is the chief minister of Chhattisgarh? Who is in tussle with his ex-finance minister. What is his name? Bhupesh Baghel became the chief minister. And 2/3 majority was backed by the Congress party, which made the BJP nervous. What should we do? Mr. Modi said, Mitro, let's amend the constitution. What will we do? We will provide reservation to those who are economically weaker, who come from economically weaker sections of the society, other than those who already have reservation. That means now 10% jobs, 10% seats in educational institutions covered by Article 15, 10% jobs covered by Article 16 shall be reserved for those who belong to economically weaker sections of the society belonging to the general category. That means those who have the benefit of the existing reservation, which means SCs, STs, OBCs, they already have reservation. But those who do not have reservation, general category, amongst general category, if there are poor belonging to economically weaker sections of the society, 10% jobs shall be reserved for them. Now, this was challenged before the court. This EWS reservation was challenged in the court. Janhit Abhiyan versus Union of India 2023, and early this year the judgment came. Why was it challenged? Saying it is unconstitutional. Why unconstitutional? On various grounds. Ground number 1, excluding the poor belonging to SCs, STs, OBCs from EWS reservation is constitutionally suspect. Because EWS reservation said, if you do not have the benefits of the existing reservation, who gets the benefit of the existing reservation? SCs, STs, OBCs. They will not get reservation under EWS. Who will get reservation under EWS? Members belonging to the general category. But by excluding the poor belonging to SCs, STs, OBCs, because amongst SCs, STs, OBCs, there may also be poor people, excluding them from EWS reservation is constitutionally suspect. It is not constitutional. Second, economic backwardness as a criteria for reservation. Constitution said originally that there can be special provision for those who are socially backward, educationally backward. Economic backwardness was not a criteria mentioned in the Constitution at all. So making economic criteria as a basis for reservation, is this possible or not? That's for the court to decide. And three, 15% reservation for SCs, 7.5 reservation for STs, 27% reservation for OBCs, plus 10% reservation for economically weaker section of the society, means 59.5% reservation, which means a violation of Indra Sani case, where the court had explicitly said reservation cannot exceed 50%. All these were challenges before the court. And what the court said, number one, avoid double reservation. Five judges of the Supreme Court, they gave this verdict. 4 judges were in favor, 1 was against. 3 judges were in favor, 2 were against. Supreme Court said, we have to exclude the poor belonging to SCs, STs and OBCs from this EWS reservation. Why? To avoid double reservation. Why? Because otherwise, I as an SC, I get SC reservation as well, I get EWS reservation as well. ST as well as EWS, OBC as well as EWS. So I get the benefit of double reservation. This should not happen. That is why it is constitutional. It is genuine. It is okay to exclude the poor belonging to SCs, STs and OBCs because they already have reservation. We are including only the poor from the general category. Supreme Court further said, when Mr. Modi came up with this idea that we should provide reservation to economically poor, 10% jobs should be reserved for them. Somebody told him, but Mr. Modi, do you know what? He said, what? In 1991, P.V. Narasimha Rao, whom you are praising today, he also provided reservation to poor. It was struck down by the judiciary in Indra Sani case. Supreme Court said, economic criteria is not a basis for reservation. Constitution only recognizes 2 kinds of backwardness, social backwardness, educational backwardness. Then Mr. Modi said, I know that, but do you know why Supreme Court struck it down? He said, why? P.V. Narasimha Rao government issued an order. A government order was issued. And through that government order, they provided 10% jobs, reservation in jobs for poor. We are not issuing a government order. What are we doing? We are amending the constitution. So it's a constitutional amendment. Sir, but then what's the difference? Constitution previously said social and educational backwardness. Now we are amending the constitution and we are specifically talking about economic backwardness as a criteria for getting reservation. So when P.V. Narasimha Rao issued an order, constitution talked about only social and educational backwardness. When what we are doing today, we are amending the constitution and we are providing economic backwardness as a criteria for getting jobs, for reservation in jobs. The Supreme Court was asked, but is it right that economic backwardness becomes basis for reservation? The Supreme Court said, yes, it's the policy decision of the government. Times keep on changing. So with the changing times, we have to change ourselves as well. Because of the income inequality that we see currently, it is possible and it is genuinely happening that there is a vast section of the people who have been untouched by these economic reforms. They're not able to lift themselves up. That is why economic backwardness can also be a criteria for providing reservation. Supreme Court was asked, but you said in Indira Sahni case, reservation cannot exceed beyond 50%. Supreme Court said, yes, we said that. But we also said in Indira Sahni case, except in extraordinary circumstances. And this is an extraordinary circumstance where a massive majority of the people, they are below the economic radar. In this situation, 50% cap cannot be, it is basically arbitrary. Why did Supreme Court say in 1992 in Indira Sahni case, reservation cannot exceed beyond 50%? How did they come up with this number 50%? Why not 40? Why not 60? Why not 90? Why 50? This is an arbitrary number. Supreme Court itself says that government should not be arbitrary. Supreme Court itself says that the laws passed by the parliament should not be arbitrary. There has to be some logic. But why did you not give the logic when you said reservation cannot exceed 50%? What is the logic? How did you come up with this number 50? Were these judges suddenly sleeping and then they got a dream and then in that dream they were told that reservation should not exceed 50%? What's the logic? They did not explain. So this 50% limit on reservation should not be cast in stone. In extraordinary circumstances such as today, reservation can exceed beyond 50%. But is it right to provide reservation for poor? There is some good thing about this reservation policy, economically weaker sections of the society, that it is religion neutral. We say there should be no discrimination on the grounds of religion, right? But who are the scheduled castes? Hindus, Sikhs, Buddhists, Jains. Not others, not Muslims, not Christians, not Parsis, not others. So when religion cannot be the basis for discrimination, why are SCs only Hindus, Buddhists, Jains, and Sikhs? So there is a religious basis to our reservation policy. But this EWS reservation is religion neutral. Member belonging to any religious community. If you are poor, you will get reservation. That's good thing about this law. There is another good thing. The stain of reservation might go away. If you are at the IIT or IIM or a central university or even a government place, you're working in the government office or anywhere, you will see that there is a segregation. There is a group of people who are having lunch at the table And suddenly they're talking, do you know why that person is here? He's got the reservation. Otherwise, he has less marks than me. These people, just because of reservation, they get admission in these top colleges. Otherwise, they can't stand a chance in the competition. So you look down upon those people who come to these educational institutions or these jobs from the reservation quota. But now, since members from the general category are also eligible for quota, you cannot question the reservation policy. What will these people tell you? Why are you criticizing us? Why are you criticizing reservation? Even you are eligible for reservation. Reservation is not just on the basis of caste. Reservation is not only on the basis of the tribal status, it's also on the basis of the economic criteria. You're also eligible for reservation. So over a period of time, the stain on reservation can go away. But this may not be the right thing to do. This reservation policy is wrong at multiple levels. One such level is reservation is not a poverty alleviation program. Reservation is for past historical mistakes. If you want to eradicate poverty from the society, give people scholarships, give them loans at cheaper rates, give them subsidies. That's how you can eradicate poverty. Give them free education, but not reservation. Reservation was never meant to be a poverty alleviation program. Reservation was never meant to be a tool through which you can eradicate poverty in the society. Reservation was to correct the historical wrongs which were committed against socially and educationally backward classes of citizens. That's the idea of Dr. Ambedkar. Not just this. Reservation for all means reservation for none. How? What is the criteria of EWS? Who is an economically weaker or belongs to economically weaker sections of the society? Who is economically poor? EWS criteria is same as OBC criteria. You might say, sir, what is wrong there? Listen to me carefully. Equal protection of the laws. Likes should be treated alike. Those who are in similar situation should be treated similarly. Through this EWS reservation, you are equating a Brahmin with an OBC. With no offense to Brahmins, but Brahmins are at a top level in the social hierarchy because unfortunately we have created a hierarchical situation. How can Brahmins be equated with OBCs? They are not alike. Their social status is different. Their educational status is different. So this EWS reservation violates equal protection by the laws, which clearly says likes should be treated alike. And through this, by having same criteria for OBC reservation and EWS reservation, you are equating a Brahmin with an OBC, which is against Article 14. But not just this. What is the OBC criteria? Annual income less than 8 lakhs. If your annual family income is less than 8 lakhs, you are a non-creamy OBC. Which means if you have less than 8 lakh salary, if you have less than 8 lakh family income, you are economically poor, you get the benefit of EWS reservation. Can you tell me what is the percentage of people who pay tax in India? Anyone? What is the percentage of people who pay tax in India? 2%, 2%, 6%, 28%, 3%, 4%, 1.5%, 2%, 4, 7, 3. I don't know how you come up with this number. Okay. That is why you should read the question, hear the question carefully. I asked, what is the percentage of people who pay tax in India? What is that percentage? 100%. Mr. Ambani buying a soap also pays tax. And a poor rickshaw puller buying a soap also pays tax. Indirect tax. But if the question is, what is the percentage of people paying income tax, which is a direct tax? 2%. Or let's put the number at 5%. Income tax law says if your income is up to 2.5 lakh, you don't have to pay tax. If your income is between 2.5 lakh to 5 lakhs, you have to pay 5% in tax. If your income is 5 lakh to 7.5 lakh, you have to pay 10% in tax. That means you are rich enough. If your income is less than 8 lakhs, you are rich enough to pay 10% in tax. But to get the reservation, you are poor. Not just this. If just 2% people pay direct income tax, or let's put the number at 5%, which means 95% people do not pay tax, which means 95% people are eligible for EWS reservation. And when reservation is for all, it means reservation is for none. That's why opposition said this is like a jumla. Give EWS reservation, but everybody is eligible for reservation. If everybody is eligible for reservation, where are the jobs? That is another problem with this EWS reservation. But be that as it may, this is exactly what happened. But then you might have another question. Sir, what about Tamil Nadu reservation policy? And in Tamil Nadu, reservation is 69%. This Tamil Nadu reservation policy is under challenge before the court. It is pending for so many years that I think I will die and the court will still not give this verdict. Your kids may be preparing for the civil services examination, whatever it is. This Tamil Nadu reservation, where the Indra Sani judgment said reservation cannot exceed 50%, but Tamil Nadu reservation is 69%. How is that possible? There are two reasons. One, the Tamil Nadu government initially convinced the courts, although now that convincing they will have to do again before the Supreme Court, that look at our population, majority of our population are socially and educationally backward. And when majority of our population is socially and educationally backward, which basically means we have to increase the reservation. Otherwise, we can't provide reservation. So since it was justified, extraordinary situation where the population itself is majority socially and educationally backward, you have to increase reservation from 50 to 69%. That was one. The second, this Tamil Nadu reservation policy law is placed in 9th schedule of the Constitution. We will discuss 9th schedule in great detail when we will talk about schedules, but very briefly here. When the land reforms were implemented in India, when zamindari was abolished in India, there came a challenge that right to property is a fundamental right. How can you snatch zamindars of their property? Even if you snatch their property, you have to pay them compensation. How can the state provide compensation to massive lakhs and lakhs of zamindars? Because the judiciary will question it. Pandit Nehru was the Prime Minister, Constitution was amended, first Constitutional Amendment Act was passed, and in 1951, ninth schedule was added to the Constitution. What was the purpose? The purpose was that any law which is placed in ninth schedule, there can be no judicial review. What does that mean? Pandit Nehru is discussing with his ministers and the members of the government. We need to implement land reforms. For that, we need to abolish the zamindari system, where these zamindars are not working on these lands. The laborers are working on these lands. And these zamindars, they have controlled thousands of acres of land. We need to abolish zamindari. And this land will be distributed to the landless laborers. That's what we call land reforms. Somebody told Pandit Nehru, but Pandit Nehru said, what? This will be challenged in the court. He said, yes, this court, my God, what will we do with this court? Anything that we do, they will challenge it. And they will say, come here, explain why you did this, why you did that. What do we do? Let's amend the constitution, add ninth schedule. So what will we do there? Any law which will be placing in the ninth schedule, we will mention that there is no judicial review. So if tomorrow somebody will question this law before the court will be told, but sir, constitution says you can't exercise judicial review, so you can't challenge this law. And Supreme Court has to abide by the constitution. I said, yes, very good. Very good. Let's add ninth schedule. Constitution was amended. First Constitutional Amendment Act, ninth schedule was added. And any law placed in ninth schedule, there is no judicial review. And so many laws, land reforms, zamindari abolition, were placed in this ninth schedule. Judiciary could not question. Then came 24th April, 1973. What happened on this date? Sachin Ramesh Tendulkar was born. But what happened on this date for us? Keshavaranda Bharti case was decided by the court. And the court said there is something known as basic structure. And no law passed by the parliament can violate basic structure. One such basic structure is judicial review. Judicial review is part of the basic structure. So judiciary will always exercise this power of judicial review. Then the question later on came before the court. Supreme Court, come here. Said, what? You have to come here. You come before us and tell me what is the issue. Sir, judicial review is part of the basic structure? Yes. But what about ninth schedule? Do you know what Pandit Nehru did? Yes, it is all Nehru's fault. What did he do? Ninth schedule was added. Any law placed in ninth schedule, there is no judicial review. I said, really? Yes, sir. But you said judicial review is part of the basic structure? Yes. When did we say that? On 24th April 1973. All laws placed in ninth schedule before this date, there will be no judicial review. That means judiciary cannot question the laws placed in the ninth schedule if they were added to the ninth schedule before the Keshavananda Bharti verdict. But any law placed in ninth schedule after 24th April 1973, there can be judicial review. But this Tamil Nadu law was placed in ninth schedule after Keshavananda Bharti verdict. That means it can be challenged. But still there is a protection available to this law placed in ninth schedule. Listen to me carefully. Can any law violate constitution? No. Because constitution is the supreme law of land. But this law, if it is placed in ninth schedule, it can violate constitution. Except basic structure. That means this law which is placed in ninth schedule, it can violate any provision of the Constitution. Schedule 1, Schedule 2, it can violate President, Prime Minister, it can violate any provision except those things which are part of the basic structure. Now, the question before the court is this 50% cap limit which is imposed by the judiciary, is this part of the basic structure? Can Supreme Court say that this 50% limit on reservation is also part of the basic structure? Then Tamil Nadu reservation system goes. Because reservation cannot exceed beyond 50% because 50% limit is part of the basic structure. But in the Janhit Abhiyan case, when EWS reservation was decided, Supreme Court did not say 50% limit is part of the basic structure. Which means this Tamil Nadu reservation law, which is placed in 9th schedule, it can violate any provision of the Constitution except the basic structure. Since 50% limit is not part of the basic structure, this law will continue. You might have another question. Sir, what about Haryana? What about Andhra? What about something that MP is also deciding? What happens in Haryana? Haryana says 75% jobs in private sector. Those jobs with less than 50,000 salary, annual income, will be reserved for those who are the domicile of Haryana. Sir, is this constitutional or unconstitutional? Is this possible or not possible? What do you think does it violate? Anyone? I'm not asking you to say yes or no. I'm saying, what do you think does it violate? What article do you think does it violate? Article 16? There can be no discrimination in jobs, only on the grounds of religion, race, caste, sex, place of birth, residence. But domicile is not a criteria. That means on domicile, there can be reservation. That's argument number 1. Argument number 2, Article 16 says, there shall be equality of opportunity where? In public employment. All those posts, jobs advertised by the state. Private sector is not a state. So any policy can be implemented by Haryana. That is why there is nothing wrong in providing reservation for domiciles up to 75% if the salaries are less than 50,000 salary. It is okay. But it is going to affect the investor sentiment. But that is something that should be taught to you in economy classes. Will the private sector then invest in a state where they are forced to source talent only locally? Will the FDI come into that state where there is a restriction on your hiring policy? That is something that investor sentiment decides. That is not something related to the law. And this completes our discussion on Article 16 of the Constitution. Any questions? Let me know. Sir, what if a person is availing the benefits meant for OBC but belong to the creamy layer? Because I know such people. What can we do in such cases? File a case? Complaint? Yes, it's no secret that reservation policy is also being misused. Please explain basic structure. We'll explain that in the amendment to the Constitution. Look at the schedule. We will discuss amendment to the Constitution and the doctrine of basic structure separately. Which article of 15, clause 4 or clause 5 gave reservation for OBCs? Reservation for OBCs in educational institution is provided by Central Educational Institute Reservation of Seats Act 2007. It's not provided by 15 clause 4 or 15 clause 5. Here, domicile is not equal to residence. No, because we discussed domicile previously when we discussed citizenship. Domicile is residence plus the intention to reside permanently. So domicile is not the same as residence. Sir, how can Tamil Nadu government place reservation in 9th schedule? It is done only by parliament. State government has not done it. Parliament has done this. So Tamil Nadu government requested the parliament that we have this Tamil Nadu reservation law, please place it in the 9th schedule. And parliament passed a law, placed it in 9th schedule. So don't you think EWS is the only valid kind of reservation? If you're asking me, I see no reason why there should be EWS reservation, because reservation to me is not a poverty alleviation program. Reservation should be only on the social and educational backwardness. Sir, can reservation be provided to Muslims as suggested by Sachar committee? There can be no reservation on the grounds of religion. No discrimination, only on the grounds of religion. So reservation for all Muslims is not possible. But reservation for socially and educationally backward Muslims comes under OBC, other backward classes. That's how in Telangana, in Andhra Pradesh, in Tamil Nadu, in West Bengal, in Karnataka, in various other states, there is reservation under OBC for those Muslims who are socially and educationally backward. Okay. In future, can EWS reservation be deleted? In future, can all kinds of reservation disappear? Yes, because reservation is not a fundamental right. When it is not a fundamental right, clearly it's not part of the basic structure either. So yes, it can happen. Will it happen? That's a different story. Can it happen? Yes. Shouldn't it be the case that only one family member should be entitled to SC/ST benefits, and then such benefits should cease for the family? This would be more radical, but I would propose a better solution. Give it only once in a lifetime for an individual. Right now, what is happening, you get the benefit of reservation at the time of college admission, then at the time of job, then at the time of promotion as well, without any benefit at the time of the retirement. You will not be retired early. So take this benefit only once, or as you say, once for the entire family. After that, this family should not be eligible for reservation. Where can I get all these case studies? Here. Where else do you need it? You're getting everything at one place. Why do you need somewhere else? Seema, what's your question? And whenever you are writing, please, whenever you are writing, sir, you're not answering my question. In the bracket, also mention what is the question. Because I may have missed your question, but now I am reading your comment. Please mention what is the question that you have. Is there creamy layer in SC/ST also? Anurag, yes, according to the Lakshmi Narayan Gupta judgment of the Supreme Court. Socially and educationally backward classes include OBCs. Yes, that is how they get reservation. If annual income is less than 8 lakhs, but the agricultural land is more than 5 acres, will he get OBC reservation? No, you are part of the creamy layer. Rohini Commission is about the sub-categorization of OBCs. So, for example, these are OBCs, but OBC is not a homogeneous group. There are various caste groups, for example, A, B, C, D, which come under the OBCs, right? If 27% reservation is given to OBCs, A would get 7%, B would get 6%, C would get 3%, D would get 1%, so on and so forth. This is what is known as horizontal reservation. Now, Rohini Commission has been set up to further look into this subcategorization of OBCs. So within OBCs, if there are various caste groups, now let's relook what percentage will be given to one caste group. Maybe some caste groups will get more reservation. Maybe some caste groups will get lesser reservation than they previously have. For that, a commission is set up known as the Rohini Commission. When it will submit its report, we will discuss it. Okay. Sir, if a Hindu is converted to Christianity or Muslim, will they get reservation? Depends on which Hindu is getting converted. If you are a Dalit Hindu converting to Christianity, you get OBC reservation. If you are a general category Hindu converting to Christianity or Islam, you will get no reservation. But if you are poor, you get EWS reservation. There are some comments which make me laugh, but you can't repeat it here. Okay. Article 17 of the Constitution, it talks about abolition of untouchability. What does Article 17 say? It says untouchability, and if you notice, untouchability is a term which is in quotes. Untouchability is abolished and its practice in any form is forbidden. When you look at this term untouchability, it is in quotes, which means not a literal meaning of the term, but it refers to historical practice of discrimination. Article 17 talks about prohibition of untouchability. Article 17 says untouchability is abolished and its practice in any form is forbidden. But this term untouchability is in quotes. That means we don't have to go through the literal meaning of this word untouchability. Touch me not. No. We are referring to a historic practice of untouchability. For example, when COVID-19 lockdown was imposed, there were millions who were quarantined. They were kept in isolation. Touch me not. So can it happen, or could it have happened, that some of these people would have approached the Supreme Court and said, my lord, my fundamental right has been violated? I said, what fundamental right? Article 17, my lord. Untouchability is being practiced. We are not allowed to move out. Who are you? Sir, COVID-19 patient. Then it's right. Article 17 does not talk about this form of untouchability. There may be leprosy patients for whom there will be a separate colony altogether. We are not talking about that literal meaning of untouchability under Article 17. We are referring to historical practice of untouchability, where the members of the Dalit community, they were forced not to come in close contact with others. They were discriminated, tortured. When the tribals were also tortured, it is that untouchability that is abolished by this constitution, and its practice in any form is forbidden. And this is the only fundamental right which is absolute, without any exceptions. Untouchability is abolished, but Prime Minister can practice it? No. Untouchability is abolished, but in this situation it is allowed? No. Untouchability of that form, historical practice, is abolished, and its practice in any form is forbidden. And to enforce this law, what if somebody still practices untouchability? We need to punish these people. For that, a law was passed known as Protection of Civil Rights Act 1955. But this law was considered to be very weak. It could still not eradicate the menace of untouchability. That is why a stricter, a tougher law was passed, known as Scheduled Castes and Scheduled Tribes Prevention of Atrocities Act, which was passed in 1986, amended multiple times, in 2015, in 2018. This is mostly known as the Atrocities Act. And what is this Atrocities Act? Let's look at the examples. If you are refusing admission to any person, to schools, for example, to hospitals, for example, only on the grounds of caste or your tribal status, it is untouchability. And it is this untouchability which has been abolished. And if you practice this, we will book you under the Atrocities Act. Similarly, preventing any person from worshipping or offering prayers in any place of public worship. Because there used to be a time where Dalits would contribute money for the construction of the temple. But once the temple was constructed, once the deity was placed inside the sacred sanctum sanctorum of the temple, Dalits could not pay visit to this deity. Dalits could only visit and pay obeisance to this deity from outside. They can't even climb the stairs. They can't visit this deity. They can only sweep the floor outside of the temple. If you are prohibiting somebody from a particular caste, particularly SCs and STs, from worshipping a temple, then you are committing untouchability, which is a crime, and you will be booked under the Atrocities Act. And this Atrocities Act is a stringent law. Stringent law in the sense, burden of proof is on the accused. What do we mean by burden of proof? Let's say, for example, there is something known as principle of constitutionality. What is this principle of constitutionality? Courts shall assume The law in question is constitutional. For example, when EWS reservation is passed, when this matter will be challenged before the court, all these judges who are hearing this case, they will assume that this law is constitutional. That's what we call principle of constitutionality or the doctrine of constitutionality. Then if you are the petitioner who has petitioned this case, who has challenged this verdict, who has challenged this judgment, who has challenged this law, you have to convince the judges that this law is unconstitutional. That means burden of proof is on the petitioner. You have to convince, you have to prove that this law is unconstitutional. Similarly, for example, murder. I killed you. For example, I killed you. Now police has arrested me. Now I am arrested. I am happy. Why? Because I don't have to prove that I am innocent. You have to prove, the police has to prove, the executive has to prove that I am guilty. That too beyond reasonable doubt. Beyond reasonable doubt in the sense, if I have killed you right now, the police will arrest me, will collect the evidence, ultimately charge sheet will be filed, and now before the courts, because ultimately courts will have to decide whether I'm guilty or innocent. I don't have to prove it. The police will have to prove it that I have killed this person. I'm chill. And that too, the police has to prove beyond reasonable doubt. Because if the police gives evidence, the court will ask me, have you done this? I said, no, look at the CCTV footage. In fact, look at the app as well. I was taking a class at 9:25 in the morning. So if the murder happened at 9:25, either I was in the class or I was killing this person. If I was in the class, I can show you that I was present there. This is the app recording. You can see the CCTV footage of the office as well. I was present. The court will say there is a doubt. You can't be present at both places. So although evidence is against you because the murder weapon has your fingerprints, but there is still some doubt because if you were taking the class, you can't murder at the same time. That means the burden of proof is on the prosecution, the executive, the police. They will have to convince the court that I've killed this person. But when it comes to the Atrocities Act, the burden of proof is on the accused. So if I am from upper caste and you are a person belonging to SC or ST community, and a case has been filed under the Atrocities Act against me that I have practiced untouchability, I have to now convince the court that I am innocent, my lord. This is the evidence in my favor. I am innocent. I am not guilty. I have not practiced untouchability. And when you have to prove something, it becomes difficult. That is why this is a stringent law, very strong law to prevent the menace of untouchability. But what is included in untouchability? One, if you are insulting somebody, the members, you are a Dalit, and the reason why you are a Dalit is that your forefathers did a mistake. Look at your dress habit, look at your food habits. You are impure from top to bottom. I'm insulting you because of your caste or your tribal status. This is untouchability. I may not be insulting, I may be preaching. Preaching in the sense, we are in a village. Here is a Dalit man or a woman, they have opened a grocery shop. How can we buy groceries from this Dalit? Let's socially boycott this grocery shop. Nobody should buy anything from this grocery shop. What am I doing? I am preaching untouchability. It is a crime. Or I'm justifying it. How can you say that you should not buy grocery from this particular shop? By Rig Veda talks about this. I'm justifying it. Our religious scriptures talk about untouchability. Again, the Swades movie example, which I remembered now. A beautiful line. जो कभी नहीं जाती, उसी को जाति बोलते हैं. A beautiful statement. Horrible one, but in this context a beautiful one to explain, to understand. So if you are insulting somebody based on his caste or tribal status, preaching, justifying, all this comes under untouchability. And if a member of a scheduled caste is subjected to any such disability or discrimination, the courts will presume that such an act was committed on the grounds of untouchability, unless the contrary is proved. What do we mean by that? I am a Dalit. You are a member, you are a non-SC or non-ST. You gave me loan of 1 lakh rupees. Now I'm not repaying you. You are coming to me, my sister is getting married, my son is getting married, or my sister is not feeling well, I need money for hospitalization, whatever the reason is. I'm saying I'll not give it. Do whatever you want to do. And then you hit me and punched me in my face. Said, my lord, atrocity. This person attacked me because of my caste. This is atrocity. When the matter will go to the court will assume that yes, you hit me because of my caste. You practice untouchability. Unless and until you prove it otherwise. Said, yes, I hit him, but not because on his caste. I swear. I hit him because he owes me 1 lakh rupees. I need that money desperately. He is not repaying that money. And that is why now he is filing a false case against me. Then if the court is convinced, the court will set you free and say this is not the case under untouchability. In 2015, no untouchability word in any Veda, sir. So, sir, don't use this type of example. My dear, I'm not saying it is mentioned there. I'm saying those who justify untouchability, they justify it on the basis of religious scriptures. Whether they read them rightly or wrongly, I don't know. But they cite the religious scriptures to say that there is untouchability. This form of practice is justified. I don't say that. These are their words. Don't lynch me for that. Our Vedas are based on Bharbat, not caste system. That's why I told you previously also, the basic idea was Varna system. That's why Mahatma Gandhi was in favor of Varna system, not the caste system. That is where the principal disagreement between Mahatma Gandhi and Dr. Ambedkar was. Varna is basically the division of labor. Those who will perform these kind of activities, those will be teachers, Brahmins. Those who will participate in the wars, those will be the Kshatriyas. Those who will carry on trade activities, those will be the Vaishyas. Those who will serve the other societies, other members of the communities, those will be the Shudras. So it was a proper division of labor. But this Varna system became caste system in the later Vedic period onwards. That's what books write. I was not present then. Okay, so we will leave it here. We will discuss the 2015 amendments tomorrow. Then we will discuss the Subhash Mahajan case, where the verdict was given in August 2018. What happened in that case, we'll discuss that tomorrow. Tomorrow we will complete right to equality, where we will discuss Article 18 as well. Then we will have a fascinating discussion on the freedom of speech and expression, where we will discuss right to freedom, Article 19, 20, 21, 22. So see you tomorrow, 6 o'clock in the morning. Shalu, is this your 6th batch or 7th batch? You are attending these classes for the 7th, 8th time, which is good. Socially and educationally backward class include OBCs? Yes, that's how they get reservation. I answered that previously as well. Does Baiju's website has the list and summary for judicial verdicts by Supreme Court? Yes. So reservation according to residence can be used only by the center, yes, and not the states, correct? And domicile can be used by the states, yes. Atrocities Act was passed in 1989. That is it for today. See you tomorrow, 6 o'clock in the morning. Till then, have a great time. Bye bye.